This is Reasonable Doubt with your hosts, Mark Garrigus and Adam Carolla.
Yeah, get it on. Got to get on the choice. We're going to mandate. Get on. Welcome to the fastest half hour or 15 minutes or 47 minutes in the universe. It is Reasonable Doubt.
Like today, I've got some dinner reservations, so I'm feeling like we're at about, and they were very hard to get, by the way, as I'm sitting here in Florida, which is about as wide open as I've ever seen any place. Try to get dinner reservations here. It's unbelievable.
Where are you eating tonight?
Biblos, which is one of my favorite restaurants along Collins Avenue. I go there every year whenever I'm here for the National Trial Lawyers. It's a Greek kind of Tenny style restaurant. They do lamb riblets that I just dream about all year long.
What goes on at the National Trial Lawyers Association Gala?
Well, there's what seems like thousands of lawyers here. One of the great things about it is you walk around and you see so many kind of legendary lawyers running around here and it's just fascinating. I mean, I was sitting downstairs last night with Tenny and my future son-in-law, and lawyer after lawyer, and I was giving her kind of the history. Like, this guy is Michael Berg, legendary in Colorado, looks great. Told me he's 71 years old. I saw another guy who is a partner of somebody that I love, Mark O'Mara. I did a presentation with yesterday. I have not seen some of the usual suspects that I always see, like F. Lee Bailey. I usually run into here. You can also, I saw Keith Givens from Alabama, and it's just a wonderful place for guys who really try cases, who are real lawyers, to tell war stories and have people listen to you. You know, I mean, telling war stories, after all, is what lawyers love to do.
So what's going on in the news? What's hot? What's breaking?
Let me tell you one thing that's kind of fun, because we talked about it. Today Unsealed was in the Southern District, was a letter that was somewhat redacted from the prosecutors in the Southern District to Judge Etkin, who is a very highly regarded judge. I've appeared in front of him, and he's fantastic. And the interesting thing, it was about asking that a special master be appointed in the Rudy Giuliani case. And interestingly, they cite to Judge Kimba Wood, the one-time U.S. Supreme Court nominee, and her decision in the Michael Cohen case. So they realized that there may be a real problem with the idea of looking at Rudy's devices without having an independent third-party intermediary. Now, we talked before about a taint team or a dirty team, and they've got that set up there at the Southern District, but they're asking that the court appoint or basically order them to meet and confer between them, the lawyers, and themselves to try to decide on a list of candidates. That person would presumably be a retired judge and would look through, in conjunction with the lawyers for Victoria Tensing and for Rudy, and see what's privileged, what's not privileged, things of that nature. So there's several reasons I think this is interesting. Number one, clearly, since Michael Cohen, they've decided to do a different approach in the Southern District, and I think the right approach. It actually mirrors the procedure in California. California provides by statute that if you execute a search warrant on a lawyer's office, the lawyer's got 3 days, and you get a list of candidates that'll come in and kind of referee it. The list of candidates usually provided by the state bar. And so the feds are following that. The other interesting thing that I don't think has been reported on yet, maybe it has and I haven't seen it, Judge Etkin is the same judge, if I'm not mistaken, Gary, I didn't double check this, but if memory serves, he's the judge who's handling the Lev Parnas case. Who, you'll remember, that was the Lev Parnas and the other guy were on their way with a one-way ticket to Ukraine. So clearly it looks to me like this is a Ukrainian-based prosecution. And I believe that they're addressing this letter to Judge Etkin because he's the one who signed the search warrants for the devices and the search of Rudy's home office and phones. And Lev Parnas, as you may remember, has been very vocal after President Trump said he barely knew the guy, and then a bunch of pictures surfaced and this or that. So it would not surprise me if Lev Parnas was cooperating or making some proffers, and that they used part of that in terms of seeking the search warrant against Giuliani.
So let's just drill down a little on what the job of this person is. So you have your client, and your client is Chris Brown, but they're interested in you for other things, and maybe some with Chris Brown, but maybe other things as well. So they raid your office, but some of this information is attorney-client privilege stuff, and it's not meant for their eyes or everyone else's. The people who are trying to prosecute you aren't allowed to use some of this information, and we need a third party to vet it and decide what they get and what they can use and what falls under the attorney-client privilege.
Exactly, and it becomes exceedingly nettlesome, if you will, when the U.S. Attorney's Office is either at odds with, on other cases, with the lawyer whose office they've searched, or that lawyer has partners who may have stuff on the devices and has current cases with that prosecutorial office. I don't know if that's the case for Giuliani, but that was the original reason for California doing that, and for California passing that statute. It's also the reason why in the case where they referenced from Judge Wood, Kimba Wood, that she decided to order a special master. I don't believe that the U.S. Attorney's Office asked for that initially. I think that was something that Michael Cohen's lawyers, I think then Lanny Davis was one of the ones who was defending Michael Cohen, and they had asked for a special master appointed, which she did in that case. And so obviously they're embracing that procedure at this point. It's kind of interesting too, because then you've got a lot of time that's going to elapse for the lawyers to prepare what's called a privilege log. You got to, every email, like if they were to seize my device and it's got something, if I represented Chris Brown or somebody else, and I've got attorney-client communications there, we're going to assert privilege there so that they can't look at that stuff, even if they're not adverse to me on that particular case. Because why does a client, because his lawyer represents somebody else, going to get have their attorney-client privilege waived? Why does the government need to get in that?
So what's this mean for Giuliani? Well, what's the implications?
I think the implications are that they are prepared to either supersede in the existing case in front of Judge Etkin, meaning when I say supersede, they've got an indictment now, and that indictment alleges certain things against Parnas and against his co-defendant, and they are either going to supersede, which means go back in front of the grand jury and seek to add Rudy Giuliani as a co-defendant, or do another indictment in the Southern District against Giuliani. To me, it's pretty clear that they are serious as a heart attack there. Interestingly, Victoria Tensing's temporary lawyer, as they refer to in the letter, is Brady Tensing. So I assume that's her son, and the son is representing her until she locates local counsel in New York.
What is the optics of executing a warrant? So Giuliani says, I've had all this stuff. They could have had it if they wanted it. They should have just asked. I wasn't going to destroy it. I would have destroyed it already. So when you authorize a warrant, you surely know it's going to get a lot of attention. It's going to be all over the news. You're making a statement. I mean, I'm assuming, but you correct me if I'm wrong, there's obvious practical reasons for warrants, and then there's warrants that seem sort of like you're just doing it for the pomp and circumstance, like, maybe Roger Stone, the troopers showed up at 6 a.m. in full gear with their, with assault rifles and everything. It was a charade.
Well, I've said that for years. The idea that if you have a lawyer and the lawyer is communicating with the prosecutors, whether it's federal or state, the idea of going and rousting people out of bed at dawn to arrest them when all you had to do was tell the lawyer, hey, we got a very vital proceeding today. Have your client meet you at 9:00 and at the courthouse. For years, that was the way it was done. And I can count on one hand, if at all, the number of times where I called a client and the client said, fuck you, I'm leaving the country. That doesn't happen. In fact, I've had the opposite, where they tell me that they've got a warrant and the client comes back and I have to have the warrant recalled because the client can't get back into the country because there's a warrant outstanding for them.
Well, like they did with Lori Loughlin, like they showed up at her house. It feels wildly unnecessary.
Well, there's a certain perverse irony here, because who pioneered the perp walk in the Southern District was Rudy Giuliani, arresting the kinds of titans of Wall Street and then walking them out the perp walk, So to some degree, payback or karma is a bitch. But look, if you're consistent, you take the position it was showboating on Giuliani's part when he did it. And, whenever somebody is kind of knocking down the doors to get at Roger Stone, Roger Stone wouldn't miss a camera opportunity if his life depended on it. If you called him and said, go down to the courthouse, he would have come down there with a phalanx of media as well. So as you point out, it's a little much.
Well, so the question then is, what are the implications? So if you're issuing the warrant, you are saying we want this to be on the front page of every newspaper. We want to make something of this. We'd like to alert everybody. And sure enough, Fox, CNN, everyone, it was all covered about Giuliani. What is the office saying when they do that, or are they saying anything at all?
To some degree, let me give the prosecutor's position. The prosecutor would argue, I think, look, we don't know if we have everything. The only way we can find out, we're at a point in our investigation where we have to make sure that we have gotten everything, so that if there's going to be an argument later on that there was exculpatory evidence, we've got it. It wasn't manufactured after the fact. I think there are prosecutors who truly believe that it's the safest way to make sure that the truth comes out. The cynic in me, and I'm more cynical because I practice defense, the cynic in me would probably make a very close argument to what Giuliani has made, which is, you could have given me a grand jury subpoena. If you've already subpoenaed the iCloud or whatever, you've got the world of that gets uploaded every half an hour. If you've got some reason to believe something hasn't been uploaded from my device, then issue a grand jury subpoena. And then if I don't comply, then you've got a slam dunk of an obstruction. I mean, that's basically what the obstruction statute is for. If you are subpoenaed and know that there's a lawful investigation and you don't turn over something that has been lawfully subpoenaed, you're obstructing that investigation. So those are the two sides of the argument. I always think that when the search warrant is issued, more so on the state side than the feds, because the old expression is the feds move at a glacial pace. But usually it indicates that you're at the beginning of the end of the investigation. It's a way to tie it all up. And if that's the case, what are they looking to do? I mean, to some degree, are they looking to have Rudy Giuliani? The part of the federal way is you get credit for cooperation. You get credit for assisting. And the only person that he could assist on would be Donald Trump.
How much
that I can imagine.
How much of this is political? If let's just say Trump was 100 days into his second term, would this go down the exact same way?
Well, I think the answer to that question is if what has been reported is true, if Trump was 100 days into his term, depending on who he had appointed as his attorney general, and maybe if he had won, Bill Barr would still be there. It's been reported that twice SDNY sought to have search warrants executed, and twice Barr said no. So if Barr was there, 3 strikes, you're out. I don't think this would have happened. So that's the argument that I've been hearing Alan Dershowitz making, that this makes America look like a banana republic. I think it's premature to say that because I don't know, and let me give some justification for that so that people know that there is a reason for that. Part also was revealed today down in D.C. is Judge Amy Berman Jackson, I believe, issued or released an opinion in a civil lawsuit on a FOIA request by a group called CREW, CREW, and I have no idea what that acronym stands for. I read it today and it went in one brain cell and out the other. But she said that the Department of Justice had misled people in the summary of the Mueller report, and that she released part of the memorandum, internal Department of Justice memorandum, as not being deliberative, and was fairly scathing in her critique of the Department of Justice in this opinion. If that's the case, you'd have to see more of, and she's letting them have a certain amount of time to see whether she unredacts some of the stuff. Once again, that gives you some more information that we didn't have even 3 days ago.
CREW, by the way, is Citizens for Responsibility and Ethics in Washington.
By the way, who is I couldn't discern from it who is part of CREW? Who is I'm interested in, because I always will take a look and see who the person is who's behind the group that's supposedly nonpartisan. Yeah,
it's these days it's pretty easy.
It's very difficult, right? I mean, it's like when you watch the TV channels and you get the differing kind of perspectives. It's very difficult to know who the players are.
This isn't a name that means much to me, but the president and CEO is Noah Bookbinder.
Okay.
So we'll see where the Giuliani case goes. I haven't.
Oh, wait, what about? Does any of this play into your conspiracy theory?
What I've been noticing is that, and my conspiracy theory is a little bit in the Dershowitz camp, which is we've kind of weaponized a lot of these federal agencies, and it kind of depends who's in charge and who's bidding they shall be doing. There was a fair amount of stuff. You'd have to watch Fox to find it because it didn't go that mainstream. But there's a fair amount of stuff involving the Steele dossier and the CIA and a lot of things involving the Mueller report and Russian collusion and all that kind of stuff. There was a fair amount of stuff in there that didn't feel that impartial. It felt like
that's why, I know. That's why, that's the flip side of this lawsuit and this ruling by Judge Jackson, and why I'm interested to read the unredacted parts when she does there, because it sure seems like both sides were spinning heavily. If you read what she says, and then if you see some of the other stuff that you've talked about all along as a counterbalance to that.
Well, I mean, look no further than the riot/insurrection. anyone who was around that situation, they're being treated very differently than many people have been treated who are involved in other riots and other situations. Now, you can say, well, this is an insurrection, but you also could say it was a riot and a mob. You know what I'm saying? So there's been a real attempt to make it an insurrection. And then once it's an insurrection, you can throw those guys in jail and throw away the key. And I think, for instance, in a world where, you know, you burn down a Target and you go in and you're out that afternoon, a lot of these guys, and I don't know if a lot of these guys are still in, but there's definitely been a different set of legal standards, sort of depending on what the people did and how much we agree or disagree with them. And I feel like in this day and age, you'd be much better off being caught burning down a Foot Locker than you would be being a part of that mob that was at the Capitol. And not even in chambers or in Nancy Pelosi's office, just being a part of that mob. They're going super hard after those people.
I thought I read somewhere, somebody just got sentenced to 4 years for one of these attacks. And I'm trying to remember where it is. Maybe Gary can find it while we're talking. You know, what you're saying reminds me, for some reason, it's been played, at least in my news feed, the Jon Stewart kind of upbraiding of Paul Begala and Tucker Carlson, which is much older clip. Then, much older because Jon Stewart doesn't look anything like he does now, and neither do I. So then they were playing Jon Stewart criticizing, and it was obviously long after, criticizing Nancy Pelosi. And it was interesting to me, at least, how one of his criticisms before was that when you have a discussion, whether it's Begala and Tucker, or whether it's, with the old Crossfire, I think was also Carville, that it was more theatrics than any kind of way to communicate. And then when he was talking about Pelosi, it was that she was raising tens of millions of dollars, and her justification was as well, we can't just unilaterally disarm. We have to fight we have to fight the Republicans. And his argument was, well, if money corrupts, then it corrupts equally, and it's not. And he, I think, said something like, just because I recognize that ice cream is fattening doesn't mean I get to stuff my face and I don't get fat. And there is there's some interesting parallels, because we've talked about this. All of the things that the Republicans were bitching and moaning about in the 90s about the politicalization of criminal law the Democrats were bitching and moaning about the politicalization of criminal law are now what the Republicans are bitching and moaning about. And, you'd think at some point that you would like to think that there are certain institutions, or as you say, agencies, that try to make a distinction, that just because there's a change in administration doesn't mean that all of a sudden you're in harm's way when you weren't 3 years ago.
Gary has the 4-year sentencing story.
Yeah, absolutely. Dylan Shakespeare Robinson, 23, was sentenced Wednesday to 4 years prison time, 2 years of supervised release, and ordered to pay $12 million in restitution for his role in setting a Minneapolis police precinct on fire. He was seen on video lighting an object being held by a co-conspirator who then threw it at the building. So he didn't even throw the thing, he just lit it. There are 3 others who have pled guilty to the same crime that he has and will be sentenced at a later date.
Well, there you go. I guess it is a two-way street.
Was that federal or state prosecution? Does it say?
Let me read a little bit and I'll get back to you.
I read about it today or yesterday, and I thought I thought about, because you'd made that argument before, and I thought about that. And then I thought about, a lot of these federal judges in the January 6th detention hearings, and that's January 6th attacks. A lot of these judges have unusual, I think, in face of continued detention requests to be freed from it, have released some of these people because part of what they were originally told, at least in two instances I can think of, they're saying is no longer the case, that maybe they were told one thing and it really wasn't. I think the guy that you referenced in Nancy Pelosi's office,
Chewbacca, man.
They said I referred to her as a biatch, not a bitch, and that was more affectionate as opposed to.
Well, I could give you examples that involved an A at the end and an ER at the end, but I don't want to offend any clients.
I'll jump in. I think it was federal charges, it says here, and it was a joint investigation by the ATF, the FBI, and some Minneapolis and Minnesota agencies.
Is Chewbacca Man still in the joint? I think he is.
That's a good question.
I believe he is, but let me check.
The guy from Pelosi's office with his feet up on the chair was, I think, released. We got Gary doing a lot.
I don't know if that's Chewbacca guy or not. So
no, different guys.
Different guys. So what do you got with any updates on Chauvin? The Chauvin trial.
So very interesting with the motion that was filed yesterday, and it appears now that they've tied together some of the things that we've talked about for the last 6 weeks, and they've put it into kind of a timeline, they being the defense. And interestingly, I think what you see is that they're all of a sudden they're focusing a lot more on the sequestration. They're focusing on the idea that the judge, if he wasn't going to change venue, he had to take some kind of remedy. I think they're setting this up. I still think that this is, when I say they are, I'm saying I think the feds are going to end up indicting all 4 officers very soon. And then they'll just kick this state can down the road and maybe kind of get pleas or have people take pleas. It's an interesting kind of backstop that they've got here. And if it's true as reported that if he had been acquitted, which I don't think either you or I ever thought there was a chance of, he was never going to be stepping out of that courthouse to do anything other than turn around and put his hands behind his back and go right into federal custody. But the specter of federal indictment, I think, either gives this judge some wind at his back or is going to let him not have to have an evidentiary hearing. But at some point, we've looked at the questionnaire, we've seen some of this other stuff. There's a dispute there. It's an interesting dispute.
Well, Gary,
what's your take on it?
I'll tell you in a second. Gary, what do you got?
Richard Barnett is the gentleman who was famously seen sitting behind Pelosi's desk. He was released at the end of April pending trial. Jake Angeli, who is most commonly known as QAnon Shaman, but Adam likes to call him Chewbacca Man, he is still in jail pending his trial, and he faces up to 20 years.
Okay. Well, so I think if you're Chauvin's lawyer, you have to say there's no possible way we could have ever administered justice with a literally a mob outside of the courthouse. You should have changed the venue, should have sequestered the jurors. That seems, and now the latest is the juror wearing the knee on the neck Black Lives Matter T-shirt. I suppose he's going all in on that. That would be my angle if I were him. I want to tease a question to you, Mark.
Okay.
You have the lead guy in Chauvin, and he's the guy who's on Floyd. So then you have the other officers, I guess 4 other officers. And
3 others.
3 other officers, 4 altogether, 3 other officers. Now, what Chauvin did was a 9, and what you did was a 3. So if Chauvin walks, then you don't really have to worry about what you did, because how are you guilty of aiding someone who's not guilty, essentially, if he was found not guilty?
Right. It's an interesting legal question, because there have been cases where guys have been convicted in that very scenario, and courts in different jurisdictions take different positions. But I hear you. But as a practical matter, you feel like if you're a co-defendant, you got your wind at the back if the guy is exonerated, who was really the principal and the main actor and the now convicted murderer.
And then it's about degrees. So if they get him for manslaughter but not murder 2 or murder 3, you feel less confident than if he walked, but more confident than if they came in guilty on all 3 counts. Well, now they've come in guilty on all 3 counts. So now, if you're one of the other 3 officers who felt like, this is just for show, I didn't do anything. Well, this guy got convicted on all 3 counts. So, and, I think we've proven that as a society, we want our pound of flesh. Like, we want our pound of flesh from these guys.
One of the theories of crime and punishment and is retribution. That's here's centuries old concept.
Here's the tease. If you were defending one of these 3 cops and Chauvin came in guilty on all 3 counts, A, what's the pucker factor for you? And then B, seeing how fast they went. 3 things: seeing how fast they came back with the verdict, seeing what the temperature is of society at large, Maxine Waters and beyond, and then C, thinking, the defense put on a pretty competent show. Like, the defense did their job, and they were convicted in 10 hours on all 3 counts. If you are representing one of the other 3 cops now, are you looking for a plea deal, or where are you at? I'll tease it. Let me just hit Geico. Do you rent your home? Well, you do one or the other. And then there's your automotive policy. Now, you got to get your bundle going with Geico so you can save a lot of money. It's a good thing, too, because you already have so much to do around the house. So go to geico.com, get a quote, and see just how much you could save. Geico makes it easy for you to save when you bundle at Geico, that is at geico.com. So as an attorney for one of the other 3 in my scenario, Mark, when you find out Chauvin got it on all 3 counts, what does that make you feel like?
Well, if you learn anything from history, and this case to me is so reminiscent of Rodney King, even though they were acquitted, it shows you by shipping the case, by changing venue from downtown Los Angeles and Rodney King out to Simi Valley, I think is where it was tried. That basically, kind of like OJ, instead of being tried in Santa Monica, bring him downtown. There's always that, you're dealing with different jurors. In this case, and in the second Rodney King trial, I think it was a split, 2 convictions, Kuhn and Powell, as I remember, and then the other 2 were acquitted. And the 2 that were acquitted, I think the one got on the stand, who was the younger one. And I think that's what you'd have to do. You would have to assess whether I believe in this case, in the case of Chauvin's co-defendants, one or more of the co-defendants were fairly new. If you assess their credibility and they look like they could get up and testify and withstand a vigorous cross-examination, you might take your chances. If I'm one of the guys who really was more experienced and didn't really intercede, I think I'd be looking for I'd probably lean towards some kind of a plea deal, because that's a tough uphill battle for you. But I could see where one of the newer officers, and I'm not in the weeds on how long they had been there, but if you're talking about somebody who was freshly minted, I can see where if the person was able to convey, hey, I'm just out here, this is the superior officer, I didn't know, blah, blah, blah. I could see where that's something where you might take your chances.
I think one guy was there
two
third
of them,
day.
Two of them were in their first week, and one of those two, Chauvin, was his training officer and immediate superior.
Yeah.
You can say, look, I just got assigned to this guy. I didn't know he was, a monster, blah, blah, blah. That would be I would assume what his defense would be.
I haven't watched all the game film, but it's a pretty easy one, which is this guy was the superior officer. I was distracted with the crowd, so my back was to it a lot, and I thought Chauvin was holding him in place until the ambulance showed up, and I was trying to keep the crowd from, causing a riot.
It also says here that the two officers that were in their first week were on duty with Chauvin as their supervisor as part of their field training. So it was like active duty field training. So you could probably make an argument that you're not going to talk back to your immediate superior in the middle of a situation with a crowd.
Yeah,
that would make sense to me. I mean, if you're going to have a defense, that would appear to be the defense. And by the way, I would be interested in what the chief of police would say if you're the chief, because his testimony vis-a-vis Chauvin, I don't see how that same testimony could be communicated vis-a-vis the two officers who were in their first week. And by the way, this one of the areas of cross-examination that Chauvin's lawyer, Eric Nelson, could not get into because, for obvious reasons, that these officers could, is to say, well, Chief, if you said this guy never should have done it, we don't train this way, this isn't our police department, why were there, 18 prior incidents where this guy had complaints against him for excessive force, and now you're having him train us, this guy who's out here for a week? What kind of hypocrisy is that?
So still the question remains, when the guy above you, Chauvin, gets indicted on all three counts, that's got to make you nervous, right? If you're the lawyer for one of the three.
Convicted on all three, absolutely. You've got to sit there and then sit down with your client and do an assessment of what your odds are. I mean, it may be the case that the state is willing, the state, not the feds, the state is willing to enter into some kind of a plea arrangement with you at that point. And you might be able to get the feds to go along with it, but you would want a global deal.
A global
because
deal.
You're not going to plead on the state case. Yeah, absolutely. Because the last thing you want is to plead on the state and then go get indicted federally.
Here's a difficult hypothetical, which is you're representing one of these rookie officers, and you understand. You would feel pretty comfortable going into this if it was any other situation, any other municipality, in any other scenario. Like, the guy's a rookie, his officer who trained him, who's the lead man, is up to something. We got this crowd. This is the first week. Minus any news coverage, minus any national and international awareness of the story, just small town. Let's just say the cop was black. Let's just say Chauvin was black and Floyd was white, and this was in some podunk town, and CNN didn't give a shit, and Nancy Pelosi or Maxine Waters had never even heard of the case. You would feel pretty damn good about getting your rookie officer off, I imagine.
Well, the pushback on that is that the case that got the second degree reinstated was a black officer, one shot, kills a white woman in Minnesota, whose
in her
name
car.
I got.
Yeah.
Yeah, in the car. And that's the case that they found a second degree. And I think he got 20 years. Gary, you'll find it for me. So
his name was really, like Mohammed or something, as I recall. But
I'm trying to remember the name.
All right, but let's just distill it down to this.
This is where I'll give you the fodder. I think nationally, I've read statistics that there's been less than 100 cases that resulted in a conviction where a cop has used excessive force. I mean, that's mind-boggling to me. Less than 100 nationally, so in a sustained period of time.
So you're the lawyer for one of the rookie cops. There is no national hubbub over the story. No one knows. Nobody cares. Exact same scenario, minus the crowd, the mob.
Yeah, but the difference is going to be whether you have other officers testifying against you. That really turns the tide. Because normally, I mean, I've sat in a courtroom where the cops come in. I've sat in courtrooms where the brethren come in wearing either uniforms or the polo shirts with the badge on it in support of the officer who's on trial. And it's very rare, exceedingly rare, where you ever have the chief testify or the lieutenant testify or anybody else. I mean, it's almost like lightning strike.
All right, I'm still going to finish this question. I've never been more correct in my life. This officer, I thought his name was Mohammed, is named Mohammed.
I'm sorry, I may have given
You're telling me I'm not more correct than I've ever been in my life?
I am giving you information on a Minneapolis shooting, but it doesn't involve an officer. So I put in all the keywords you gave me, and I thought I was looking at the right thing. I'm sorry.
A white woman called the cops.
Put in second degree.
A woman called the cops and I think ran down to the cop car, and the cop shot her through the car. I think the guy was on the passenger.
That was the facts of it too.
He was on the passenger side, so it's like some blonde chick called the cops. The cruiser rolled up. The woman.
This was the Australian woman, right?
I think so. Yeah. The woman rolled down, and the cop shot her from inside the car.
All right, I have good news and bad news. Only one Muhammad, but it is Muhammad Noor.
Yeah.
You were right.
Jesus, Adams. I think Crystal Brain is unbelievable. Noor is what I remembered, but I kept thinking Azur or Noor, but
yeah, and
he got a sentence to how long?
12 and a half years, and then the city settled with her family for $20 million.
So here's what
there was a 20 in there.
God damn. I wish
the victim's name was Justine Damon, by the way.
All right, so back to my hypothetical. I'm just saying, as a lawyer for the rookie cop in any other situation, you would feel pretty good about your chances. But
Correct.
This is not that. And
this isn't even close.
It's not even close to that. So are you saying? So what? I don't want to put words in your mouth, but here's what I'm saying. I'm saying you think under any other circumstance I could get you to walk on this case, but maybe not this circumstance, and maybe you should plea. Is that a thought?
I have. I'm trying to think of the exact situation, but I have told clients in the past, over the years, depending on what the temperature was at any one time, that if you had been arrested 2 years, 5 years prior, I would have told you go to trial. And now you have to weigh the consequences of whatever the temperature is in society, because that changes. It's frequent. And if you don't advise the client of that, I think you're to some degree ineffective, because there is clearly at certain times, I remember during when California was crazy about 3 strikes, and it seemed like every case I was trying had a life top, meaning no matter what the crime was, you were exposed to a life sentence. And people were freaking out, and about crime and crime on the rise, and we had to do something about it. I'm talking about the 90s. People forget just how crazed we were at incarcerating people. And there were times when I advised clients to take deals because the risk, the cost of going to trial and losing was astronomical. And so, yes, that does factor in, and it has to.
So what would you say if you were going to defend these guys? Would you want a change of venue? Would you want sequestration?
I'd want to change of venue. I'd want sequestration. I would want the judge to, he's already severed. He had Chauvin case severed from them. And I would tell the judge, I think I would use everything the judge has said to show him, look, judge, for the exact reasons that you severed this case, for the exact reasons that there's now a motion for a new trial, for the exact reason that it's being reported the feds are going to indict if you get acquitted, there's no way you can have this case tried here in this courthouse, and you make a fulsome record. And instead of it being kind of speculative, you've got a whole litany of things that you can cite to the judge as to why he should do something. And one of those things might be, judge, you got to just adjourn or continue this case for a period of time until we kind of work through all of these things.
All right. Last fun hypothetical game. I would be very worried if I was these guys' attorneys that these guys could get a fair trial. I considering where we're at as a nation. And I would be very worried that we would want to exact our pound of flesh, and the media is going to go all in on this, and the pundits are going to be equally as hyped on it. And if you said you get 1 year in prison, that's your plea, you'd probably take that, correct?
Correct.
But what if it was 7 years in prison? Would you take that?
Some of the hearkening back, I'm going to answer it with having lived this. Hearkening back to 90s, 2000, even as recently as 5 years ago, there have been times, and there are cases. There's a federal case specifically that in California we call it a People versus West plea, WEST, which is, and then federally it's Alford versus North Carolina, or North Carolina versus Alford, where you are maintaining your innocence, but you're taking the plea because under the circumstances you feel it's in your best interest. And we have recognized that in the law. However, federally, most federal judges won't let you do that. Most federal judges insist that you articulate or allocute a factual basis, and it's got to be a detailed factual basis. And that's a problem. So in this case, it would be very difficult for one of these officers to plead statewide in the state case if they didn't have a federal component where he didn't have to articulate a factual basis, because I'm not so sure that one of the rookie officers could articulate a factual basis.
So just for the sake of pure hypothetical, would you accept 6 years? Forget about federal. Forget about the feds.
No, I think you'd make a compelling argument that anything over 3 years for one of the rookies was way too much time.
But that is in a United States, pre-Floyd and pre-pandemic. Like, I just feel like, I don't know, Gary, what they're charging these guys with, but I would be very worried about them getting the maximum if I was representing them.
Minnesota has a sentencing guideline calculation. So they know what the guidelines are. And then there's whether there's aggravating and mitigating factors. You could make a compelling argument, I suppose, for mitigating factors. And I'm not so sure that anything over 3 for one of the rookies would be the case. I'm not so sure that the Attorney General's office wouldn't offer 3 years to one of the rookies.
What do you got, Gary?
They're being charged with aiding and abetting second-degree manslaughter, which is interesting to me because he was convicted of murder. So
right, and you don't know.
It doesn't say what the sentencing.
All right,
guidelines are.
Right? Well, Garrigo's got lamb kebabs waiting.
I've got the lamb is waiting for me, and it's mouthwater.
I know. You Armos, you love your sheep, don't you? All right. This Saturday, tomorrow and Saturday, I'm going to be in Appleton, Wisconsin at the Skyline Comedy Club, doing shows there, 2 shows Friday, 2 shows Saturday, and Jam in the Van, Los Angeles. That'll be May 22nd. And then you can go check out, Saturday's episode with Gary and Mark as well, Beyond a Reasonable Doubt. Mark, what do you got?
And if you want to watch Beyond a Reasonable Doubt, only available where, Gary?
On the Reasonable Doubt YouTube channel, which is youtube.com/Reasonable Doubt Podcast. Go there and subscribe.
And come downtown to downtown LA and eat at Engine Company or 10E. That's my plugs for the week.
So until next time, Adam Carolla, Mark Garrigo saying mahalo.
Thanks for listening to Reasonable Doubt. Tune in next Saturday for an all-new episode.